Member LaHood?
Aye.
Member LaHood, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Stein?
Aye.
Member Stein, aye. Member Forsley?
Aye.
Member Forsley, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member Wong?
Aye.
Member Wong, aye. Member Yankee?
Aye.
Member Yankee, aye. Member Highland, absent. Chair Wolf?
Aye.
Chair Wolf, aye. Moved by Member LaHood, second by Member Neighbors to rescind the current OD or order determination.
Very good. Okay, so we are now at the point of deliberation period. We've heard all the merits of the case. We've heard the testimonies. We've heard rebuttals. The action that we had taken at that time, and I'll read it verbatim from the minutes, moved by Member Padmanabhan, seconded by Member Frazier, to continue the matter to the next Sunshine Ordinance Task Force hearing to allow the respondent time to conduct a signal search for records within the next 7 days and to allow the district attorney's office to determine if a signal search was performed on the original request, period. In addition, the task force requested that the matter be monitored by the Compliance and Amendments Committee after the next SOTF hearing. So we charged Compliance and Amendments to monitor this on the task force's behalf, so to determine whether it's ready for prime time coming back to us today. So I'm going to hand it back to CAC Chair LaHood and say, what is your findings? And how should we, what should we be considering on how to proceed at this point?
Well, it seems that at minimum, we have a violation for failing to comply in a timely and complete manner. And that we know because the signal search was not done when the original request was made. It has been completed now. There were, I believe, 5 responsive records that were found that were withheld because of attorney-client privilege. I believe we were still, that was part of one of the previous motions in our May hearing of the full task force, but it was not clear what was happening in that direction, and perhaps the makers of those motions, if they want to revive what they were thinking at that time. But we ended up moving in the direction of feeling as though we didn't have enough information regarding the signal search, and the respondent at the time was willing to complete that within a short time frame to give us more information about this. But it was determined that it was not conducted when it was originally requested. It had been conducted subsequently. We do not have information about the app settings, and we were advised by our assistant deputy city attorneys that though we might request it, going in that direction was taking things a bit far afield, and also that the app settings were not part of the original request, and it's perhaps allowing we'd be allowing ourselves to go farther than necessary, or maybe farther than appropriate in pursuing information that was not directly part of the original request. It's also very difficult to know, based on what settings are, whether there may have been responsive documents, or excuse me, responsive records that no longer exist, because we can't know.
Okay. Anybody else from the committee have anything else to add?
Yeah, I will add that We did go, we questioned very thoroughly and did a lot of consideration around this, but one of the things that I think we really landed on, Mr. Campos was there representing the DA's office, and we finally got to the understanding that though they did not literally search the devices or the settings of all the employees, because they mentioned that it was not on the advice of their counsel, that it was not an appropriate or a required activity, but that they did ask every employee to search their own records to determine if there were any, or their own apps to determine if there were any responsive records, including those that were Signal apps, and that using that system, they had ascertained that there were no responsive records. So kind of an honor system, I guess.
Okay,
If I could interject,
go for it.
just on what Member Jones Neighbors was talking about, the Smith v. Superior Court case, or Smith v. San Jose, which is California Supreme Court, talks about how you deal with these retaining these types of messages, and what the local government, the sort of the processes by which the local government should try to figure out how to capture them, or what it has to do to capture them. And the sort of the one line that the Supreme Court came up with is that you can't really ask the government agency to tell people to bring in all their phones and then they get inspected within the office. But you would want to have more of a situation where the agency or employer sends out a request to everyone saying, look, we want you to inspect your own devices and get everything off them relating to this search. And we expect you to bring those in. So that's how it's sort of like parceled out in terms of responsibility. And that's the plan that Supreme Court sort of approved in a way. It sort of left it up to localities, but that's the extent to which they sort of described how it should work.
I would also add that with regards to Smith versus San Jose, and I might be echoing Member Schmidt here, is that it puts the full control of retrieval and disclosure of information and or records in the hands of the owner of the device. And the only way that anybody else gets to see it is if a court, if there's a subpoena. And even if there's a subpoena, I don't know if you remember the federal government trying to get into iPhones that were encrypted, that even the federal government couldn't get into a personal device. It was took a very long time. It was very difficult. So I think it's a very high bar when it comes to that. And I'm not necessarily in agreement that the settings are a public document. And if there's some concern that there was some misuse of devices in order to hide or prevent the disclosure, then I think that needs to be determined by a court. Court created this particular provision. This was not a legislative item. This was not passed by the voters. This was part of case law. And it can be very complex. And I'm not sure that we're equipped for it, because at the same time, we're to be adjudicating the CPRA and the ordinance broadly, not narrowly. And so if we feel that there was a violation of withholding of some sort, and that was incorrect, we take that on a very broad basis. But to try to get into the weeds of whether a device had settings set that could possibly remove certain or all messages, we have no way of knowing, even if we get that info, we have no way of knowing when that actually happened because of the way those types of apps are designed. And so I don't think it's necessarily in our purview to have access to a person's device. That would possibly need to be done in camera, which we don't have authority to do. And we don't have authority for subpoena power either. Vice Chair Yankee, sorry.
Yeah, just to kind of build upon that, I think that makes it that much more important that we concentrate on why timely responses to these types of things are so important, because who knows what kind of auto deletion settings are out there. There's obviously no way that we can figure it out. But the length of time, obviously, that has gone on between when this was initially asked for and when the signal search was actually conducted, that was a long span of time, right? And so I think that shows why I'm hoping whatever motion we come up with really does narrow in on that timeliness factor, because I think that this case demonstrates why that's so important.
Okay, and just to also refresh your memory, if you read the minutes from that meeting, the original motion that was made was by Member Padmanabhan, second by Member Frazier, to find that the DA's office violated Admin Code Sunshine Ordinance 6721E by failing to respond to a records request in a complete and/or timely manner. 6726 by failing to keep withholding to a minimum, and 6727 by failing to provide legal justifications for withholding. That is what we started out with, and then from there we went towards the Signal app issue. So let's pick it up from there. Vice Chair Yankee.
Yeah, I was going to say, if I recall, we had discussed, and I'm not sure we were all in agreement at the time, about whether or not there were some attorney-client privilege withholdings, and whether or not that was appropriate or not. I think that's a separate issue than the timeliness issue. So maybe it's worth revisiting that if that's still a concern among the members.
Okay. I don't see that necessarily in the minutes, but that could have been discussed at the time.
Originally in
Member Neighbors.
in the January meeting, I think that's when there was originally discussed that there were 5 documents that were held back because of attorney-client privilege, and we clarified the client was the DA office and the city attorney was the attorney of record. I think those are the documents that you're talking about, member or Mr.
I think there was some type of, I forget which meeting it was in, but if I recall, there were a handful of documents that were withheld for attorney-client privilege. I'm not sure we ever settled whether that was appropriate or not, or inappropriate, but that I think was separate than the searching of the devices and doing so in a timely manner. I'm not sure that we need to. I don't know if there's still concerns amongst those documents. I mean, just me personally, I share what the recommendation that Member Hood talked about timeliness. That seems to be, to me, the crux of this case, and what concerns me the most. But if anyone has, comments about those documents, I don't recall personally having concerns about those.
I think it's just difficult with attorney-client privilege, and we've run into this again and again. There's not much more we can do about it because we don't have the opportunity for in-camera review. We just sort of have to take them for their word on it. I think Mr. Andrews, well, and I don't want to speak for him, but I believe in previous meetings he has questioned that, but I don't think there's much more that we can do about those specific, the 5 documents that have been withheld for attorney-client privilege.
Yeah, and I could tell you, even courts don't do in-camera review except in a very unusual case when it's about attorney-client privilege. So to me, you assert the privilege, you've got an established relationship with the attorney. That's just something that it's pretty much privileged.
Well, according to our minutes, there was testimony from Mr. Andrews that Ms. Burke did not indicate attorney-client privilege on the 5 documents that were not provided as an issue, and there was no reason for withholding the records. So was there what transpired with regards to that at the committee level?
We weren't focused on that. We were focused on the signal search.
Okay. Then fine. So are we satisfied that the signal search has been completed and done?
We are satisfied that it was completed and done within the past 2 months. It was not completed when originally requested. But we should, we have the parties here, or I assume that the parties are here if members have questions that they want to ask them directly.
David Campos is here on behalf of the District Attorney's Office.
Welcome, Mr. Campos. Is Mr. Andrews here?
I am. Can you hear me?
Yes, we can hear you.
Okay.
So has the search for the signal messages, has that been completed?
Mr. Chair, thank you for your service. I don't think anyone can question anyone's commitment here, given how late it is. But as was noted by the committee chair, we did complete the search, and we have found no responsive documents. And the only responsive documents that we have found that we are withholding are the 5 documents that the Madam Chair identified.
Great. And so what about the part where Mr. Andrews had stated that Ms. Burke did not indicate attorney-client privilege on these 5 documents at that time?
Yeah, respectfully, I don't know exactly what time he is referring to, but we have asserted that those documents are protected by the attorney-client privilege. As much as we have a responsibility to provide responsive documents, we also have a responsibility to protect the interests of the taxpayers of San Francisco. There's a lawsuit that was filed by Mr. Andrews' client, and there are interests that the city has, and pursuant to those, we asserted that privilege. So I don't know exactly what he means in terms of when we failed to assert that privilege, but we believe those 5 documents are privileged.
Okay, thank you. Okay, members. I guess this is the crux of that matter.
So this is Attorney Shane Andrews. Do I have an opportunity to make comment as well?
Sure.
Great. So I just for this committee's benefit, I never expected at this hearing anyway. I thought the attorney-client privilege issue was laid to rest. I understand that the signal settings are not available and you cannot require them. That is, I've moved past that. What I'm, and I apologize if I'm mistaken, it is late, but what I'm most concerned about is I believe I heard again this evening from a committee member the same misrepresentation or misunderstanding on which this committee is operating, that the DA's office verbally or in writing questioned employees about whether they had responsive documents, because I had to be, uncharacteristically disruptive at the last hearing so I could get the committee members to focus on the fact that that same misrepresentation at the previous May hearing had carried into the June hearing until finally Ms. Burke, was forced to answer a very direct question. Did you, was there any written communication? No. Well, did you go and ask employees? No, they did back-end searches of Mr. Boudin's account. I think Ms. Burke, and to be completely, candid, she said that if there were employees that were spoken to, it was whoever Mr. Boudin said he communicated with on Signal. Okay, so that, again, so I want to make sure I'm being completely honest too. That's what I heard, right? And so regardless, Signal has been a complete detour, right? An important one, but still a detour. My request was very clear in that I wanted communications to and from Mr. Boudin regarding Mr. Osley, emails, letters, phones, apps, all these things. And again, Signal, by the way, only became a detour because we identified it as one. And yet, for some reason, we all now focused in on Signal, but it's also our understanding now that perhaps the DA's office has opted for a different messaging app now that this one has been identified. So, the idea that why we went so narrow about Signal rather than messaging apps, I have no idea. Bottom line is, the request was not complied with when it was requested, because all that happened is they looked only at Mr. Boudin's emails in his account. So then all that time passes, and then we get here, and so I have no idea what was done. And then even when I thought we were finally going to get some sort of assistance in the process to say, okay, well, at least explain to us, the steps you took. Then even then, when they said what little they did, apparently the committee said, yeah, that sounds sufficient. And I don't think that was the original interpretation in May when it made the determination of those violations, because I even heard public commenters, when they comment on what's happened at these hearings, they know it. And so it shouldn't be a secret or a surprise. I mean, the emails, they didn't respond even, it wasn't just Signal, it was emails and basically every electronic communication that existed within that office was not searched, and no employees were questioned as broadly as Mr. Campos would have led this committee to believe in May, that, questioned regarding responsive information. So it didn't happen from the beginning. Frankly, it didn't happen at the last hearing, hasn't happened at all. But, I'd be satisfied with at least what I'd heard previously, that the committee make a determination that it didn't happen and refer it to the Ethics Commission, because it cannot refer the DA to himself.
Okay, thank you. Members, we were trying to ascertain what all the communications might have been. The text messaging part came up. That was not, at the time, I believe, was not searched. And that was the purpose of referring it back to committee, just so we had a complete file. I'm going to reread the request that was made of the DA by the petitioner. It states, quote, all communications to or from Chesa Boudin regarding Thomas Osley, including emails, phone records, texts, letters, memos, and written communications, including meeting/telecom notes, whether communicated by public or private telephones, smartphones, computers, laptops, or through other means between January 1st, 2019, and the present. And the present at that time was February 4th, 2020. Okay, so that is what is before us. Have we got, what are we, where are we with regards to all those documents? We had, as I reiterated, we had started with a finding of violation of 6727, 6724, 26, 24I, and wait a second, nope, I'm in the wrong place here.
I think you had said 6721E, 6726, and 6727.
Yeah, my that's I'm in the wrong place. Yeah. So that's where we're at. Yes. 21E, 26, and 27. Okay. So there's no motion on the floor. Is there any other debate or deliberation that's needed? Is there a motion?
All right, this is Vice Chair Yankee. I'll make a motion. I'll move. The District Attorney's Office violated 67.21B for not searching all messenger applications at the time of the request.
Second.
I think there's more than that. I mean, what about the ones that we just mentioned? I mean, timely and complete manner is certain.
Right.
But was this case only about the text messages? It wasn't. It was about other documents.
Yeah.
Right.
And we did the extensive back-end email search was ongoing while we were dealing with this case, and clearly did not happen when it was originally requested.
So I mean, I'll more broadly include it to all records requested. You know, the timely, I'll say 6721B for not, timely searching all requested records within the prescribed time period. I'm not sure the other ones that were in the motion we discussed apply to this. I think those were related to the attorney-client privilege things. So I'm not including that in my motion. If someone wants to amend or make a separate motion, you can do that. But I think that we've dropped the attorney-client privilege documents, so I'm not comfortable going there with my motion.
So you're saying 21B and 21E?
21B, unless, did you see how 21E fits in this?
You know what? I may have misstated.
Let's talk about petitioning the task force for a record determination. E is, so I'm not sure. I'm seeing B.
Well, but the complainant is stating that the other records were not, I think, were provided in a timely manner.
Right. That's why I'm moving for 6721B for the requested records not being searched and provided in a timely manner.
I thought I heard you say just for the text messages.
I'm I guess amending my own based on member Levitt's input to more broadly the requested records.
Okay, I would suggest instead of putting a motion on the floor that we discuss what items are, what the violations could be, so we can formulate a cohesive motion without having to do a million amendments.
Okay, I can rescind if you prefer. You were asking for a motion, so.
Yeah, I know. I hear you.
So if you like, I can
But
rescind. If people want to
if-
discuss, I'm happy to go that route instead.
No, keep it.
if there's
For a
some,
moment of silence.
if all I'm saying is if there's some indecisiveness about the motion and it needs to be expanded, then I would say, hold off until you get your bearings.
Would the members prefer discussive? So I will remove my motion from the table. There was just a very long moment of silence, and there was a request for a motion. So
Yeah, no, I hear you. I appreciate that.
I rescind my second.
Matthew, you're rescinding your motion?
Yes.
sure, I'll rescind it.
Okay. So you have a, okay, Member Padmanabhan, go ahead.
I think we need to include 67.21C in addition to B, where it says provide a custodian of a public record shall assist a request in identifying the existence, form, and nature. And it goes on to say that provide in writing within 7 days following receipt whether, well, the previous line says whether or not the contents of those records are exempt from disclosure and shall, when requested to do so, provide in writing within 7 days. I think I was, the original motion was refer to this and not to E. I think there was a mistake made.
So it should have been B, not E?
No, it was C, not E.
C, not E. Okay.
Yeah.
Okay. So you have 6721C, B and C?
Yes.
That
E
what we're considering? Okay. Anything else?
That adds in that they didn't claim exemptions. Is that what you're thinking on that one? Adding the C.
So the justification for withholdings?
Yes.
So that's 6727. Okay. So 6721C, B and C, 6727. Is there a 6726? That came up in the previous meeting also. So if not, okay. If so, okay.
What's the 6727 for?
Failing to keep withholding to a minimum.
Did that happen?
Did that happen?
I mean, I understand they took a very long time to search the records, but I'm not understanding if there's an allegation that they're still withholding things that shouldn't have been withheld. I mean,
Except for the attorney-client privilege items.
I think.
I know, we already.
Yeah, there's a dispute about the attorney-client privilege,
Well,
which is not going to touch right now. But I think we'll just limit it to 6721C and B, perhaps.
Okay. All right. I think.
Bruce, can I say something quick? I thought 6727 was for failing to provide justification.
It's 6726. Oh, no, 6727. You're right. For failing to provide legal justifications for withholding. We agree. We're considering that.
All right, so just
Okay. So now, ready for a motion. Okay, got all your points. Is there a motion?
Well, someone else try this time.
Well, we've identified all the points.
Okay, I'll make a motion to find violation of Sunshine Ordinance, section 67.21B and 67.21C.
Can you be specific about what those violations entail?
67.21C for failing to provide the records in a
Failing
complete,
to,
timely manner. There's a echo.
are we not including 6726?
No,
I'll second.
Who is that?
Moved by member Padmanabhan, second by member Schmidt, to find the San Francisco District Attorney's Office in violation of Administrative Code 6721C and 6727. Correct?
I thought it was 21B and 21C.
Oh, B and C? That's it? Okay. So 6721B and 6721 B for B
timeliness.
for timeliness and C for assistance, right?
Yeah.
Could you be clear? Is it B as in boy and C as in cat?
Yes, B is in boy, B is in Bravo, C is in Charlie.
Thank you.
Okay. Public comment.
Anonymous number 3.
Do we have other public commenters?
This is Shane Andrews. Parties are not allowed to speak during public comment. Is that correct? I just didn't have an opportunity to say something.
That's correct, not on the actual motion. Since you were provided full testimony before, and we gave you opportunity to speak.
You did. Okay, thank you.
Are there other public commenters? Okay, anonymous number 3, are you ready?
No, there's an echo, and I ask that you first fix the echo before I start speaking.
Yeah, Mr. Leger, it's coming from your end. If you can mute your mic, you can't mute your microphone. If you can move your phone away from your computer, that might be helpful.
Is that better?
A little.
Okay. Okay, anonymous number 3.
Go ahead.
What? Anonymous number 3, are you ready?
Yes, I am.
Go ahead.
Thank you. I think you should make the wording for the 6721B violation a little bit more specific, and the wording I would suggest is for not conducting a timely search of all responsive records in the constructive possession of the Office of the District Attorney. And that clearly states what they failed to do. And the reason is because in the end, they still aren't turning over any records. So in the sense of timely kind of providing those records is not exactly what happened. It's the fact that they did not conduct a timely search of all responsive records in the constructive possession of the Office of the DA. And this matters because if he wins this motion, if Shane Andrews wins this motion, he'll go back to compliance. And I think you can ask them a simple question. Have you now conducted a complete search of all responsive records of every kind of form they requested, whatever IT searches, messenger, it doesn't matter, in the constructive possession of the district attorney's office, and they better be able to tell you yes. So that's why I would suggest that wording, and consider a 6727 violation additionally if they did not cite in writing within 10 days of the original response prior to the complaint the attorney-client privilege justification. Thank you very much.
Do we have other public commenters?
Yes, please. Can you hear me?
Yes, just a moment.
Yes, who? Peter Warfield?
I said just a moment.
Who are you recognizing?
Please
recognize Peter
be
Warfield.
patient. Please be patient, speaker. The administrator will address you when she's ready. Thank you.
Mr. Warfield, are you ready?
Yes, let me know when to start.
Go ahead.
Peter Warfield here, Executive Director, Library Users Association. We can be reached at libraryusers2004@yahoo.com and by mail at P.O. Box 170544, San Francisco, California, 94117-0544. We're not a party to this and not familiar with it except for the discussions that have been held, and of course we're concerned with sunshine in the pursuit of what we do and want it to work well. I want to say, and I've said it multiple times here, when you say yes or okay or we hear you, there have been times when I was literally thinking you referred to me, and then I heard one after another other people having public comment and what seemed like me being ignored. And that's because you were not specific about who you were saying you heard or didn't hear, and that made it impossible to understand whether we were being heard or not. There's no confirmation if you don't give some kind of a name. With respect to this item, first of all, I'd like to agree with anonymous number 3. I think it's very important to be very specific always with respect to what it was specifically, what action specifically caused the violation that you are finding. There are going to be problems with anybody making sense out of it, with anybody finding meaning in it, if you don't do a very specific, as much as possible, specification of what it is that people did incorrectly according to what you have found. So I would certainly agree with his amendments. I would also ask, why are you leaving out 67.26, which was alleged and discussed and so on? The withholding was not kept to a minimum. I think it's clear that they didn't, well, let me just leave it at that. With respect to order of determination, you often, and even earlier today, have said you order people or urge them to do something specific. And so I would ask you to include in this an additional thing in which you say that you urge them to do a specific action or actions to remedy what they've done and to make sure there's progress or compliance by the time it reaches follow-up at your compliance committee. Thanks very much.
Any other public comment? Last call, public comment. Okay, public comment is closed. Members, you ready for a vote? Okay, here, you're on mute, Member LaHood.
We ready?
Hang on.
Hold on.
No.
Go ahead. You can. No, you're on mute again. There you
Are
go.
we interested in any of the suggested modifications, or are we happy with what we have at the moment?
I would please not ask a question, and if you have an interest in something, then I would suggest bring it forward so we don't prolong the pain here.
I think what we have is sufficient. More detail, I'll let somebody else pick this up. I'm 3 time zones ahead.
Okay. All right, are we ready for a vote? Hearing no objection, please call the roll.
Member Padmanabhan,
Aye.
Member Padmanabhan, aye. Member Member Schmidt,
Aye.
Member Schmidt, aye. Member Neighbors,
Aye.
Member Neighbors, aye. Member Stein,
Aye.
Member Forsley, did she have to leave?
She did. She
Yes,
left.
she did.
All right. Member Wong,
Aye.
Member Wong, aye. Member Yankee,
Aye.
Member Yankee, aye. Member LaHood,
Aye.
Member LaHood, aye. Member Highland, absent. Chair Wolf,
Aye.
Chair Wolf, aye. Moved by Member Padmanabhan, seconded by Member Schmidt, to find that the District Attorney's Office in violation of 6721B for time limits and 6721C for failing to provide assistance to the petitioner.
Thank you. Just note for the record that Member Forsley left sometime around 10:30. Okay, please call the next item. Thank you, parties, for sticking around. I know it's late. I would appreciate your patience through this process.
Thank you.
Thank you.
You're welcome. Okay, please call the next item.
Item number 8, Chair's Report.
Okay,
Project-
so go ahead.
I was going to read the items. Project Catalyst Program, system-wide advisories, and annual report to the Board of Supervisors.
Okay, so the only item I'm going to discuss in detail is number 1. Number 2 and number 3. Number 2 you can read in the attachment. Unfortunately, I was unable to finish writing the advisories, but I'll get to it after the first one. And then the last one is the annual report. Will just be, it's just a query for you folks to start sending the items to include in the annual report. With Project Catalyst, I've been creating a number of projects and then creating work groups that are passive meeting items, essentially. So they are recorded and they can be attended. And so this first one was to start dealing with our backlog. And I chose to work with one petitioner who has quite a number of files with us, and that is anonymous number 3, and which we'll call anonymous number 3. He identifies himself in these meetings as such. And so we've met a couple of times, and through those meetings, which also included Vice Chair Yankee and Member Wong, just as from kind of the chair level. Member Wong, if you remember, is shadowing Vice Chair Yankee and I on administration of our task force here. So this is kind of an administrative item. It doesn't necessarily change, that we, the final outcome. The final outcome will always be an order of determination. But what it does do is query the respondents as to whether they admit noncompliance of the ordinance with regards to the complaint, or they plead no contest. And for those items, we will bring to the task force on a consent calendar. Okay? Public comment, I haven't figured out how that will work yet on this, but essentially with public comment on a consent calendar item, we can provide a considerable, at some time, to address any one or another items in the consent calendar. It can be done. It can be done any number of ways. Not quite there yet on that part of the process. So right now, what you see in the attachment is kind of a treatment on how the process would work. And so what I'm presenting to the task force is a proposal to, as a pilot project, to continue working with Anonymous number 3 to identify specific groups of complaints. We're going to start with the one group, which will be Prop G calendars, and determine of the multiple requests and responses and then complaints that have been filed with us on Prop G calendars, which ones of those respondents have admitted noncompliance or have declared or pleaded no contest. We'll put those all together as one action item for all those items, and then we'll take a vote by consent calendar. That will, if we can get through 5 to, or 10 items in one consent calendar, that's in 1 or 2 whole meetings, and we will have reduced our backlog pretty, significantly. And if we continue with this program, it should help streamline and expedite our backlog fairly quickly through the end of the year. Any discussion, any questions, any suggestions, any objections? Okay.
I'll just say that I commend this is Member Schmidt. I commend the attempt to come up with creative ways to do whatever needs to be done to attack the backlog, because the backlog is, to me, I don't know if I've ever mentioned this before, but it's really like my personal pet issue number 1 in this. And I don't know if this would be everything that was needed to get that backlog back down, but I really like the idea of thinking outside the box to create a mechanism like this. Thank you.
Well, the one thing I will say as an added value to this is that it presents us with also the ability to review the work that Anonymous 3 has been doing, and will help us if, starting with system-wide advisories, to be able to identify key problems with the implementation of the ordinance. And so that's another feature of this at the same time. But we do want to assure that all complaints that are coming forward receive an ordered determination of some sort, either positive or negative, whatever it is, in support or not in support of an ordered determination. So by clumping together all the ones where there's no contest, it's pretty clear. the outcome should be at that point. It doesn't remove the ability for reconsideration by any of the parties. That will remain. So if there's nothing else, yeah, go ahead. Somebody wanted
Yeah,
to.
sorry, I don't know if I missed this, but are petitioners going to be asked if it's okay with them to have their things grouped together, or will it just be done by the task force?
Well, so this pilot program, we're right now working with anonymous number 3 primarily.
Okay.
It won't be with any other petitions, because this will be, it's a good, the work that they've done is so extensive with the number of complaints that are the majority, or at least half of the backlog. And so we have to deal with that batch in order to reduce it. So that way everybody else gets a turn. And we limit how many there could be per meeting, but if we stay the way we're going with still more complaints coming in by the bucket load, we'll always be in a backlog. So there's got to be some way to do this. And so here's one way we can try it. It's a pilot program.
Right.
If it works, and we can expand it and scale it up. If it doesn't work, then we'll continue to find some other way. This isn't the only thing in my head that I'm trying to work on and that I've taken suggestions from all of you for. This is just the one that's kind of ready to go.
No, I get it. It sounds good. It sounds like it is with the consent of somebody who's got a lot of petitions in, and it sounds good.
Okay, great. Because anonymous number 3 has been directly working with us on this, I'm going to give him a little bit of time to, he's been part and parcel to these meetings, to, if there's anything else he wants to expand on with regards to this program.
Sure, this is anonymous number 3. Do you want me to speak?
Yes, if you'd like to. It's up to you.
All right. Sure. So I want to be clear. It's not only with my consent, it's with my wholehearted consent. And I hope that if the pilot does prove itself out, that this becomes somewhat of a standard thing. And I think I've discussed this in emails before, that you can ask for all complaints a written kind of plea, even if you're not bunching them together, just so you know what is actually at issue. I think some of today's complaints showed that if you can know in writing what is disputed versus what is not disputed, I think it would help everyone. I have 2 suggestions to change some of the wording that's in the current draft. I have sent those as an email to the task force. I can read them into the record if the chair would like me to, or I can also not. But I was just suggesting some very precise wording so that it's fair for everyone and no one thinks that they're kind of losing due process, and so it's very, very precise what's happening. So
I would like you to read into record, because I'm going to entertain a motion to approve the pilot.
okay, let me pull it up 1 second. All right, so I am proposing, and I'm going to read this out, that the wording of the kind of the plea or contest question sent by the administrator to every respondent that is in this pilot says the following, quote, does, in a placeholder name of specific respondents alleged, parentheses respondents, admit to non-compliance or declare no contest to all allegations in the below complaint file, placeholder file number, against you, please choose one answer. You may, if you wish, also attach any additional explanation. A, admit to non-compliance for all allegations below. B, declare no contest to all allegations below. C, deny one or more allegations below, parentheses, please state in additional explanation which of the allegations you deny and supporting evidence and or argument. Next line, complaint allegations. And then this is the important part. There's a placeholder for the exact OD or a violation wording proposed. So they have exact notice of what's being proposed. And the final paragraph reads, If respondents admit noncompliance or declare no contest, the SOTF may, at its discretion, issue an order of determination against the respondents for the allegations listed above without a hearing, and thereafter refer the matter to the Compliance and Amendments Committee for monitoring as needed. And then there's a second quote I can read if you have all that down. So
I think that was a little fast for Ms. Leger if she was typing. But
it is in a direct email. It's an exact copy of the email I have sent to Ms. Leger. So
okay, great.
Okay, you sent this email to me?
It's an email. Yes, it's an email sent on July 30th at 1:33 p.m. from my standard Proton mail. Yeah. And then the second thing is the proposal for the exact wording for the consent agenda item. That is, quote, shall the SOTF accept the written admission of noncompliance and or declaration of no contest in the respondents in files, and you list all the file numbers, comma, issue orders of determination finding violations in all files without conducting a hearing, comma, and refer the matters to the Compliance and Amendments Committee for monitoring, and that would be the question.
Okay, and that's all in the email that you sent on July 30th?
It is all in the email on July 30th, 1:33 p.m., correct.
Okay,
Right,
and I will, go ahead. Ms. Leger, do you have something else you wanted to say?
No, I didn't know if he had something else he wanted to tell me.
Nope.
Okay.
Nope, I'm okay.
So I just want to add that we've already been working on the addition of the question with regards to this. Victor has already started putting that into some draft form. So we're kind of, 90% ready to go here. I'll entertain a motion to approve the pilot program. And if you all agree, then we'll get started.
Is entertaining a motion the same as making a motion?
Yes. I'm entertaining it from you, any of you.
So
No. I'm not making a motion.
Okay, I'll make a motion to approve the pilot program.
I'll second the motion.
Okay, so moved by Member Stein, second by Member LaHood. Any other discussion, members? Okay, public comment.
Yes, I'd like to make public comment.
Certainly, Peter Warfield.
Mr. Warfield, you ready to make public comment?
I have to get the timer going here.
I have a timer.
I'm ready.
Go ahead, sir.
Peter Warfield, Library Users, 2004 at yahoo.com. Also P.O. Box 170544, San Francisco, 94117-0544. Executive Director of Library Users Association. I find this extremely alarming and wrong. You are supposed to do your decision making in public. And here we are, we don't know for how long this is going to run. We don't know what the specific restrictions are on what this applies to. A very good question from one of the members was, will the petitioners be asked whether they want to participate in this? There are also serious questions about a hearing. I think it's very important for the task force to understand why and how the respondents have violated the law, if in fact they have. It may be different for different people. There may be causes. Your understanding and your guardianship and monitoring of Sunshine, I think, depends on understanding. Just to have a bunch of pieces of paper that say, oh, we violated, okay, sorry. Where is the, for example, plan to fix anything? Where is the monitoring for fixing anything? Anonymous 3 does a lot of research and is very knowledgeable about what his concerns are and what violations he may find. But not everybody is that knowledgeable. In our case in June against the Library Commission, one of your members actually came up with a specific violation that we hadn't focused on, though we provided the information that made it possible. The initial complaint that we had was simply that we weren't able to make public comment and that was not a proper opportunity for public comment. All of the details, how did it happen? What were the issues? None of that is going to be explored here, nor is it even going to be clear what the violation was, what sections of the law were violated, and why. Was it some plan? There's a lot you can do to
30 seconds.
improve your process with getting out of backlogs, which I certainly agree with. But that might include going for the mayor, going for whoever are the big violators, going for who's responsible. Also discussing with people whether to put 6 complaints on one agenda and then having them pull out at the last minute, possibly because they didn't get enough notice. There's a whole range of things you can do to improve your process. But to cut back on the people's right to know what's going on, for you yourselves and the public to learn what's going on, this is very wrong, and it's been all done in secret.
Thank you, speaker. Next speaker, please.
I would like to speak, Cheryl.
Mr. Monette Shaw?
Yes, I would like to speak.
Okay. Are you ready, sir?
Yes.
Go ahead.
I cannot believe this meeting started at 4 p.m. And we've heard at least, 6 or 7 times Mr. Warfield's contact information. Once is enough, Peter. Just say it once in a meeting and people will know how to get a hold of you or not. You've wasted a lot of time during this now 7.5-hour meeting. Repeating shit we've already heard once, which was enough. I would, addressing this motion, suggest that it needs to be amended that to provide the great advice coming from anonymous number 3, who I deeply respect, even though I don't know who that person is, that if the respondent, the accused, agrees to a stipulation of either one of the 3 options, that the process should then go to the complainant and say and ask complainant, are you willing to waive a public hearing because the respondent has admitted some form of culpability, and it's not enough in my book to get the respondent to admit wrongdoing without asking the complainant whether they will bypass all other processes and agree to accept a stipulation. Thank you.
Next speaker.
Yes, may I be heard?
Do we have another speaker?
Yes, this is Hank Heckle.
You ready, Mr. Heckle?
Yes.
Go ahead.
Hi, good evening, Task Force. I don't want to belabor this hearing, which is already running late. I appreciate everyone is a bit worn out from the process and the time. But as to this Project Catalytic project and series of meetings that's been transpiring, and sounds like it's going to continue, I trust that that being a policy body, that those meetings will be noticed and agendized in accordance with the Brown Act and the Sunshine Ordinance, because it is a committee that is created by a policy body and is therefore itself a policy body, not a passive meeting body. That's consistent with the city attorney's advice and the Good Government Guide. And also, since Anonymous has been working to resolve his backlog, the SOTF's backlog of complaints, which is largely a creation of Anonymous's complaints, I would hope that the task force would notice and include the respondents to these Prop G complaints in any discussion of combining them, setting them up for some kind of expedited review and resolution. This task force, its own rules require that any correspondence with a party to a complaint include the other party, and therefore all discussion of these Prop G complaints and the resolution thereof, I would hope would include all respondents, departments going forward. Thank you.
Do we have other public commenters?
Sullivan?
Are you ready, sir?
Yes.
Go ahead.
I just want to say I agree with Mr. Heckel, the need for openness and inclusion of the recipients also in determining the pilot program. The only way, and I do think that you need to try various things. The real thing that's going to bring down the caseload or get people to comply with the Sunshine Ordinance is some more teeth. And so I would start looking at how to provide teeth to the ordinance. That's it. Thank you for your time.
Do we have other public commenters?
Okay, closing public comment. Okay, so a couple of quick responses. First of all, the task force has never been deemed a policy body. The actual description for a policy body, we don't even have the authority to create policy. So it's never been described as a policy body. I've never seen it in writing. It's never been identified in the charter or anywhere else in city code as to be that. The task force self-imposes itself to comply with the ordinance as an example. In this case, with regards to these work groups, the work groups were created by me, and they were for advice for me so that I can work on and gather information to be able to create these proposals. This proposal is coming from me. The work group was specifically advice for me under, and that I followed explicitly under 67.3 C with regards to number 1, advisory committees created by the initiative of a member of a policy body, the mayor or department head. I just kind of figured I'll follow that. So I don't feel that there's any non-compliance with regards to the passive meeting body. The 67.4 describes how that all works out. with regards to noticing and what have you. And so all of that has been done. Those meetings have been recorded. You can request the recordings from our office, and they will be made available to you. With regards to hearings, if you go to 6721E, you will, and this is something that was not just came out of the blue. This has been suggested and very strongly argued by members of the public in public comment many times, that the task force is not required to hold a hearing. And it's just a single sentence in 6721E that says, where requested by the petition, the Sunshine Task Force may conduct a public hearing concerning the records request denial. Okay? It is not a requirement. Even if it's requested, the task force has a choice whether to conduct a hearing or not. And we've heard about this many times, sometimes vociferously, from members of the public. So for this particular project, the idea is to focus on where there is actual no contest or a full admission of noncompliance. That's where we're starting at, because that's the easiest way to identify that there is a very clear outcome for it, because there's no defense. The defense has conceded to the complaint. So you know, I take a little offense that we're not fulfilling our duties by. We have no requirement for holding a hearing. So we're taking a little advantage of that for this one very specific area. And if the petitioner, moving forward, if the petitioner feels that an item should go for a hearing, it's up to the petitioner to make that request. And the task force has always honored the request from the petitioners if they wanted a hearing. And we have a multitude of hearings all the time. We don't not have hearings on these files. So that's my response to the comments that were made tonight. Vice Chair Yankee, and yeah.
Just a very, very brief response. I know it's late and everyone wants to go. I just wanted to point out that, you know, with 140-ish pending complaints, we've now spent roughly 2 hours per complaint just at this meeting alone. At that rate, it would take us, if not one more complaint came in, 35 months to complete the backlog. 35 months, assuming not one more. So I understand that there's a lot of input about, you know, the process and everything, but I'm concerned that this, well, I mean, it is no longer possible to manage if we do 2 hour hearings for every complaint. 35 months is, I think everyone would agree, is just not acceptable. So I think we have to be open-minded to try new and creative ways. I think this is an excellent chance to try something new, to expedite things. I think, you know, the public, you know, deserves to have their time before us. And waiting 35 months is not going to be, I think, acceptable to anyone. So I'm excited to see this go through, and I thank everyone for their input and their hard work on it.
Member Stein.
Yeah, I'll just add briefly that because I think this is something that the petitioner is opting into, and because the respondents are only being put into this process if they do not contest that they made a violation already, I think it's, from my perspective, okay not to have a hearing, and that the point of our task force is really just to ensure that people comply with the Sunshine Ordinance. And hearings aren't always the best way to ensure that compliance. And so to me, this is a very low stakes way of trying to ensure compliance and get through our caseload.
Anyone else? Are we ready for a vote? Okay, hearing no objections, please call the roll.
Member Stein?
Aye.
Member Stein, aye. Member LaHood?
Aye.
Member, excuse me. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Forsley, absent. Member Schmidt?
Aye.
Member Schmidt, aye. Member Wong?
Aye.
Member Wong, aye. Member Yankee?
Aye.
Member Yankee, aye. Member Highland, absent. Chair Wolf?
Aye.
Chair Wolf, aye.
Results?
Moved by Member Stein, second by Member LaHood to approve the pilot program.
Okay. Project Analytic Pilot Program. Okay, thank you. The second item is with regards to system-wide advisories. I'm not going to get in too deep with it. You can read the minutes from the EOT meeting. I will say that I think I was a little bit not thinking about my own personal time that I have available to me to have a draft prepared for you today. But at the same time, I was feeling that legal counsel should review it before that. So this will, I think it probably have to wait till next month. This particular issue, for this particular advisory, among many others, this first one would be just addressing time limits. And you'll see in the report what the different aspects are. So if you have any input or, happy to take it and I'll address it in the draft of the advisory, and I'll get some legal counsel to review it, and then I'll present it in the September meeting, for approval to be sent out. And that'll remain with the EOT committee until such time. Is there any public comment? Is there any comment from members first on that? No. Public comment on that.
I would like to make a comment on Patrick.
Yeah. Oh, before Patrick speaks, I just want to say I received a very well-written input and suggestions for this from Patrick, and I will be including as much of that as possible as reasonable into the advisory. Go ahead.
So I can speak, right?
Hang on a
Yeah,
second.
just wait for Cheryl to start the clock.
You ready, Mr. Shaw?
I am.
Go ahead.
Chair Wolf, I cannot thank you enough. I am 70. I've been happily retired, laughing all the way to the bank every month when I deposit my pension. So I just want to get off the phone and climb into my new Pendleton wool blanket and go to sleep. I'm exhausted. But thank you for acknowledging that I drafted potential language that I really want you to review with the city attorney and incorporate as much of my suggestions as you can. I look forward to seeing the draft presented to the public before you adopt it. I think it's really important that you start getting these advisories sent out quickly and then posted to the task force's website as a resource for both potential complainants and respondent departments to refer to see past rulings, the task force has made, and to the extent that getting that information posted online may help reduce the backlog by departments knowing whether they're going to lose any attempt at fighting a sunshine complaint. That will help reduce your backlog. So thank you very much. I'm going to go climb under that new wool blanket. Thanks, folks.
Next speaker.
Anonymous number 3.
Are you gonna have to speak up? I can barely hear you.
Anonymous number 3, can you hear me?
Yeah, now I can hear you.
Okay.
Go ahead.
Thank you. I think this is a fantastic idea. Thank you to Mr. Manette Shaw for drafting this. Thank you to the chair for pushing this forward. I hope you do many more of this. This is when people talk about you need to do things that help, that are trying to fix the issue system-wide, city-wide. This is the first step, and it's got to start somewhere. And so timeliness is probably the simplest apparent wide misconception by most of the city compared to the SOTF interpretation. I know that there are many other types of these things mentioned by the EOTC committee as future agenda items and stuff like that. I hope you consider all of those and make your interpretations about the Sunshine Ordinance well known, because the other competing bodies who interpret the Sunshine Ordinance, namely the City Attorney and the Ethics Commission, which have generally far narrower interpretations of the Sunshine Ordinance, often in direct conflict with you, they make their views very well known. And this is one way to try, at least for the agencies who are willing to comply but just don't know, right? They genuinely don't know that they might be able to change their ways. Of course, there'll still be some agencies, maybe many agencies, who will argue that Dennis Ferrer said something else, we're just going to go do that. But at least you have an attempt to get the agencies who want to improve, who do claim in good faith that they want to change things, to be able to do so. And I hope you make many more of these. Thank you.
Anonymous number 3 is my hero, and he deserves an SOTF award. Thank you.
Next speaker.
Peter Warfield. Did you hear that?
Yes, I did.
Don't give us your friggin' address again.
Oh, please,
No,
Mr.
stop.
Manette Shaw. Please.
I'm going to start the clock again. Mr. Warfield, are you ready?
I am.
Go ahead.
Good evening, Peter Warfield here, Executive Director, Library Users Association. And we say these things because we think they're important. And
blah, 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 blah.
Hey, Mr. Manette Shaw, please. That is disrespectful.
And if somebody doesn't like what we have,
unnecessary.
if somebody doesn't like what we have to say, that's possible, but so be it. We can be reached at libraryusers2004@yahoo.com and also by mail at P.O. Box 0544, San Francisco, California.
Please stop the clock. Please stop the clock. And folks, not disrupt the meeting, please. Thank you.
Where are you going to start the clock, please?
Can you please add 15 seconds to the clock?
I couldn't understand that. It's blurry. It's a problem with the phones or whatever.
Please.
Are you ready, sir?
Where is the clock starting, please?
The clock is going to start at 2 minutes, 45 seconds.
Okay. Tell me when to start, please.
You can start.
I didn't hear that. Did you say start?
Yes.
Not sure where I was. libraryusers2004@yahoo.com and also P.O. Box 170544, San Francisco, California 94117-0544. I want to commend the publicizing and the education, if you like, of all of those who were affected with respect to this issue of timeliness. This is exactly the kind of thing that I think the Sunshine Task Force needs to do more of, and it's part of what I have been talking about over months with regard to Section 67.30 and following sections, where you have the ability and the right and the duty to educate and inform folks in your capacity as guardians and advocates of open government. I think that this, I wish that you would have had Mr. Monette Shaw's letter here so that we could all of us see, and not just the people that apparently have been in on the whatever meetings or communications you've had. I think it would be useful to make all of that stuff public.
It'll be in the minutes.
There are many more things that you can do to make known your activities and what your view is of Sunshine. As Anonymous has said, Anonymous 3 has said, many times your interpretations are different from other parties, and they make their views well known. I think the task force should be much more active about enforcement and about publicizing what it's doing and what it's observing and what problems it's encountering, including what seems to be a tremendously widespread violation on multiple departments all over the city, basically a flouting of the law. And I think that the task force needs to make very public not only its specific findings, but also the more general pattern that it clearly is observing. Thank you very much.
Thanks, Peter. Last call for public comment.
Yes, may I comment?
Go ahead.
Go ahead, sir.
Hi, this is Hank Heckel. I just want to thank the members of the task force and the participants for their commitment. We're coming up on midnight here. This is obviously a long and difficult process, this meeting tonight, but I had to note, because I find it, respectfully, I'm frankly stunned to hear from the Sunshine Ordinance Task Force, the arbiter of open government laws in San Francisco, that it is not a policy body. I'm going to read to you the definition of policy body from the Sunshine Ordinance, section 67.3, D, sub 3. A policy body shall mean, among other things, section 3 says, any board, commission, committee, or other body created by ordinance or resolution of the Board of Supervisors. Now I'd like to read from the Good Government Guide from the City Attorney. Policy bodies, quote, may also create other policy bodies through less formal means. For example, if acting on behalf of the commission, the chair forms an ad hoc committee, the committee may be a policy body, even though the commission did not formally create it. Therefore, I would repeat my recommendation and my urging that going forward, the task force notice and agendize these project catalytic meetings with Anonymous or other individuals in accordance with the requirements for a policy body, and that any correspondence relating to specific complaints not be done ad hoc and ex officio solely with Anonymous, the complainant, and without the very many tens of hardworking city employees that are answering those complaints on behalf of their departments. I would hope that those people would be included on all correspondence on that subject. And I am, to be honest, I'm extremely disturbed to hear that, there's this kind of insider discussion by certain members of the public and the task force about letters that haven't been disclosed. And frankly, this meeting has gotten a little bit off the rails at the end. We have a member of the public showering abuse and cursing and insulting at another member of the public to no consequence. And I find that very disturbing and not consistent with the otherwise good work that this task force does to maintain open and welcome good government. Thank you.
Thank you. Next speaker. Last call for public comment. Okay, public comments closed. I'll just say 67.3D3 you have to read the whole sentence. Any board, commission, committee, so policy body shall mean any board, commission, committee, or other body created by ordinance or resolution of the Board of Supervisors. Sunshine Task Force was not created by the Board of Supervisors. It was created by the voters. And so I don't quite follow that. That's been the big contention, including how the charter regards the ordinance. Most folks have told us that we're not a policy body. The Good Government Guide, that is an interpretation of the city attorney who has not included us and is required by the ordinance to include us in trainings. And so it's been very hard for us to adopt that in any kind of way. So I'll stop there.
I would strongly urge you to get advice from your DCA on this question. Thank you.
We have actually. Okay, anything, Member Schmidt?
Yeah, just the policy body issue. I just want to clarify that I don't have any opinion on that at this moment. I haven't looked into it, but just wanted to say that there may be 11 different opinions on that here, possibly. I don't know. So it's not like we're making a decision on that issue. That's all.
Thank you very much. And just, I don't think there's anything more. I mentioned before, if you have any thing to provide or add to annual report, even members of the public, you want to email them to me, that's fine. Please do so at SOTF@sfgov.org through our office, so we have a track record of who's sending what at what time. That ends my report. Thank you. We can call the next item, members, or if it's really too late, somebody can make a motion to adjourn.
I would like to make the motion to adjourn. You don't have to accept it, but I'd like to make it because I think it's very late. I think it's hard to focus now, and it's just been a marathon meeting.
Yeah. There's a motion on the floor to adjourn.
And that was Member Stein, for anyone who's wondering.
Is there a second? Okay, hearing no second, we'll move on with our agenda. Please call next item.
Item number 9, administrators report, complaints, and communications. Okay, let me get into the report. All right. The report is dated July 29, 2021. Item number 1, I have listed all hearings that are potential to be scheduled. Of course, there are possible cancellations. We don't know what the mayor is going to do about opening City Hall, excuse me, opening City Hall, but here they are from August to October in correct order, starting with Task Force, EOT, Complaint Committee, and Compliance and Amendments. Excuse me. We got several new complaints in July. They're all listed. For item number 3, total complaints. This month's total complaints actually went down a little. From last month being 152, this month it was 146. We did get new complaints, but we also closed a number of them, as I think committee members know. We have included a complaint from 2018, which is Mr. Sullivan's request for revisiting his complaint. I included the minutes from the complaint committee, July 20th. I had several communications from Anonymous to the task force, which I've included. And I have outlined the number of requests we got from community persons. They were, as of July 23, 312 emails. That doesn't include anything administrative or not having to do with task force information. So after that are the minutes, July 20th. And on page 1162 begins the public communications from Anonymous. And then following those, are the email communications that I received in the month of July during the dates otherwise noted. June 18 to July 23. Does anybody have any questions? Okay, I take that as a no. Shall we go for public comment, Chair Wolf?
Yes, please do.
Do we have public commenters for item number 9, the administrator's report? Calling for public comment for item number 9, the administrator's report. Chair Wolf, it doesn't sound like anybody's there.
Okay, public comment is closed. Next item.
So I read the next item.
Yes.
Item number 10, announcements, comments, questions, and future agenda items by members of the Sunshine Ordinance Task Force.
Anything, folks?
Well, since I'm still here, can I just ask if I want to put something on the agenda for the next meeting, is that a matter of just I write an email to you, Bruce, and say I want to put this on the agenda, or do I have to, is there some other process?
No, there's no other. Usually agenda items, come from committees a lot of times, but if you have a specific item that you want to put on the agenda, send it to through kind of our inner office communication, send it to Cheryl, and then she'll forward it to me. That way we have a paper trail and we're not revealing our email addresses in that way, and it's part of our kind of official record.
So if I want to send it through a committee that I'm on first, then I would just write to the committee chair that I want to put it on the agenda there? Okay.
Correct. Anything else, folks? None. Any public comment? Member Stein, can you mute yourself because we can hear you typing? Thank you. Public comment on number 10. Last call. Hearing none. Is there somebody there? Who's that? Nope. Okay, public comments closed. Last item.
Item number 11, adjournment. I have 12:04.
For motion to adjourn.
I make a motion to adjourn.
By Member Stein.
Seconded.
Second by Member Long. I'm making me nervous there for a second.
Member Long,
Okay.
you make the second?
All those in favor say aye.
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 Opposed? Okay, we are adjourned. Thank you.
Night, everybody.
And my apologies. Sorry. Have a good night.